You may proceed.
Mr. Chief Justice, may it please the court, I am Adam Dreyer, Assistant Prosecuting Attorney with Ionia County, here for the people. I would like to reserve 2 minutes for rebuttal. Offense variable 8 requires a score of 15 points when a victim is escorted to a situation or to a place of greater danger. In the present case, the trial court found that score appropriate when the defendant transported his 2 children to and from a video store while intoxicated and with the possession of marijuana. The Court of Appeals, though, found that that score was precluded as a matter of law because the movement was incidental to the scoring offense. Now, the Court of Appeals erred in 2 ways. First, it applied the same protection that's granted to individuals charged with kidnapping to those individuals convicted of any crime against a person. In other words, it confused the asportation element of kidnapping with just plain Jane asportation. The second error is that in applying that protection, the Court of Appeals mistakenly chose the wrong offense for the underlying offense as is required. The people would ask that this court grant its application for leave to appeal or, in the alternative, issue an opinion reversing the Court of Appeals and providing guidance to the lower courts on precisely what is needed in order to score offense variable 8. I would just note that this court has yet to issue an opinion on OV8, and I would invite questions at this time. But speaking first to whether asportation element is the same as just plain Jane asportation, I would ask that this court note that in People v. Adams, this court granted this protection to defendants after realizing that a plain reading of the kidnapping statute would allow a prosecutor to charge a capital offense for what may be factually only a 93-day misdemeanor, with juries being none the wiser. So this protection wasn't given by the legislature at that point. It was, in fact, judicially created. And it wasn't until this court issued an order in People v. Thompson where that protection was given to OV8. Now, the Court of Appeals in this case did rely on that order in order to find whether the underlying offense applies. So speaking specifically to my second point then, if Thompson did correctly show that this court would like some sort of protection given to defendants convicted of any crime against a person, I would like to note that here, the Court of Appeals, when taking asportation, this plain Jane asportation, out of the context of kidnapping, what they did was they misinterpreted what the underlying offense would be. Now, it was in the context of kidnapping, it's this morphing of an underlying offense into kidnapping that requires this specific actual incidents to be related, the movement to be related to the kidnapping, not necessarily to an underlying offense. But when it's taken out of the context of kidnapping, what we have is that the OWI under 16 is the offense. It's not an underlying offense. So even if the same protection as granted to those individuals with kidnapping is applied to all defendants, then the underlying offense here would be the possession of the marijuana. So the trial court would not score it if the movement was merely incidental to the underlying offense of possession of marijuana. But what the Court of Appeals found here specifically was that the movement was incidental to the OWI. And I would ask that this court reverse the Court of Appeals. If there's not...
In order to do that, do we have to overrule People versus Spanky, however we say that?
I don't believe this court would have to overrule People versus Spanky.
Why not?
Mainly because the finding that OV8 and kidnapping are relatable enough to put them together was all in dicta. I would ask the court also to note that asportation is not only used in kidnapping. It's also used in larceny. And in larceny, we don't have this protection. So it's the morphing that requires the protection, whereas with larceny, it's simply the same any movement, but it's not given this movement related to the larceny because there would be no other offense. Just like here, OV8 is not another offense. It's a factor that courts determine, an additional factor that courts score in order to find what the appropriate sentence the legislature recommends.
Is there any reason to believe the legislature didn't want double counting?
Well, in offense variable 8 itself, it does say that courts should not score with the offenses of kidnapping. In that sense,
Right.
it would imply that because this movement may have already morphed into kidnapping, that the legislature would not want it scored for kidnapping. But it's
for
as
everything else, there's no indication.
that's correct. There's no indication not only that this protection was granted, but that the legislature even wanted it to apply in OV8.
Do you want to reserve the rest of your time?
I would, Mr. Chief Justice. Thank you.
Good afternoon. May it please the court, my name is David Zoglo, here for appellee attorney for Mr. Abrego. I would like to start preliminarily by saying that my client was paroled on 3/23/2016, and I've been able to contact him recently, although it was difficult. So I feel at this time that the prosecutor's application for leave is moot, and we'll be filing a supplemental motion to dismiss with the appropriate papers. And I would cite the case of People versus Hershey, 497 Mish 959, which basically the case was dismissed because the defendant in that case was paroled. In our case, my client's already served over his two-year minimum sentence, which and the guidelines only apply the minimum sentence only.
Is he on parole?
He is. He's on parole. But that being said, there are two issues in the case: whether the offense variable 8 should be scored at sentencing for Mr. Abrego after conviction for operating while intoxicating second, and also whether the court can consider conduct discretion when scoring the offense variables. I think OV8, if you look at the history of OV8, it's kidnapping type conduct. Current kidnapping statute was amended, but before that there were two other statutes. The old statute, this court read asportation requirement into the kidnapping statute in People versus Adams. The legislature was thinking about the old kidnapping statute and the asportation requirement when it adopted OV8. OV8 started and took effect on 1/1/99 when the guidelines were enacted, and has not been amended since that time. Under the old kidnapping statute, OV8 asportation did not include movement that was merely incidental to the lesser crime.
For a baseline, what does the crime of operating while intoxicated require?
It requires a person operating a vehicle while intoxicated.
Does it require movement?
It requires movement.
I beg to differ. Are you familiar with City of Plymouth Longway versus Longway?
Oh, I'm sorry. I misunderstood the court's question.
I think
is the-
what I'm suggesting to you, that the crime is complete if a person who is intoxicated has physical control while intoxicated. Isn't that a correct statement of the law?
I don't believe that to be true. I believe the crime is complete once the person stops. They're driving their vehicle and they stop.
If a cop finds you behind the wheel with the car on and you in physical control, that you're saying that you cannot be convicted of IOL?
You can be convicted, but that's not necessarily the completion of the crime.
Well, even more explicitly, a person clearly has actual physical control of a vehicle when starting the engine, turning the ignition on, applying the brakes, or shifting the vehicle from park to reverse. Much more was, of course, done to the children in this case. Isn't that correct?
Correct.
But actual movement is not an necessary element of OUIL.
I would agree, but disagree on the completion of the crime.
But just a moment. I'm trying to. This, unlike kidnap, is a crime that's completely can be performed without any movement. So I'm curious to understand why the actual transportation of these children isn't asportation. That is entirely consistent with the scoring that was given in this case.
If you look at the elements for asportation, it's placing the children in a place of greater danger or
Well, if you
situation.
put them in a car with a drunk, you have, and then you move them onto the highway, how is that not a place of greater danger?
It's a place of danger.
But isn't it a greater danger than when they were back at home? Like if they were at home and not in their drunk parents' car, they're safer, and the danger got greater when they were in the drunk parents' car, right?
And the drunk parent takes them onto the highway. It's one thing to sit in the driveway, but when you move the car into traffic, that's a place of greater danger. Would you not agree?
If they're sitting in the car and the car is not moving,
Okay.
and they are sitting in there, person is intoxicated,
Yep.
no movement, sitting there,
Uh-huh.
my position would be that at that particular time, if they're in their driveway, that they're not in a dangerous situation.
Okay.
And then
Yep.
the situation gets greater, or the situation becomes a dangerous situation, not greater danger, but becomes danger when they take the highway in the car.
Well, that's not really, so either going from no danger to danger or danger to greater danger, it's still greater in the second part, right? I mean, danger is greater danger than no danger.
Yeah, I'm having
Yes.
difficulty if you're saying that children who are at home are not taken to a place of greater danger when their intoxicated parent puts them in the car and drives anywhere. Are you seriously disputing that? I mean, you can at cost, and that's at the cost that what you're saying is perhaps not believable.
I guess what I am disputing more is when the crime is actually completed. Because if you look at the McGraw case, in this case, the prosecutor argued that the crime was completed once the defendant put his foot on the brake to shift into drive, once he starts moving.
Yeah.
And if that were true, then McGraw would preclude any scoring after that, because once the crime is completed, there can be no additional scoring. And so, I believe the legislature intended to consider the conduct that occurs during the drunk driving or operatingly intoxicated, not after. So I guess my position is that occurred, that it's all one continuous motion. I understand the questions about the danger, but it's one continuous motion. He's at the video store.
No, he's at home.
Well, he's at home, but he wasn't actually, he was observed drinking at the video store in the parking lot. Then by, I believe it may have been an undercover police officer or somebody of that nature who alerted the police, then was followed home. At that point, we don't know how his driving was or what his situation was when he drove the children to the video store.
Okay.
So, him getting in the car with the children starts the dangerous situation. It's a continuing movement. I mean, he did not veer off. He didn't go and drive off in a field or do something like that.
Across the center line.
He did. He did. But as in most, I don't want to say most operating or drunk driving cases, there usually is some problem with the driving. That's why they get pulled over. There usually is weaving.
Yeah, and
or
he
speeding.
didn't have presence of mind to stop when the cop activated the lights and sirens.
I saw that, but I also saw that he did not, according to the pre-sentence report, he did not speed up. He did not try to evade police in any way. In fact,
I think
once
if
he
you
was
don't
pulled
stop,
over,
that's evading, right?
what's that?
If you don't stop, isn't that evading?
It's not. He stopped when he heard the siren.
Okay. He couldn't see the lights.
Well, I can't say for sure. but I can say that he did stop when he saw the siren. He wasn't charged with evading the police in any way, no fleeing, eluding, anything like that.
Okay.
Is it reasonable to want to punish somebody more severely when instead of simply sitting in a car in a parking lot with the motor on, you actually move the car into the highway? Is that not something the legislature might reasonably wish to do?
I think when the legislature, what they intended for OV8, and if you look at the history of OV8, OV8 is kidnapping behavior. It's severe behavior.
Actually, you can't score if the underlying crime is kidnapping.
It's everything but kidnapping, right?
Yeah.
It is, but if the elements of it, the reason why you can't score it is because the elements of it, asportation or captivity, are essentially kidnapping.
Yeah.
Do we have that in this case? I would
Do
submit.
we have what?
Do we have OV8 behavior? Do we have this asportation and captivity in this case?
Is that
I would say no.
asportation? Movement. Isn't that what asportation means?
To a place of greater danger, or to a situation of greater danger,
And
like
you're
in
not
Spank.
yet conceding the sky is blue, that when you put children in a car and move onto the road when you're drunk, that's a place of greater danger.
I would still submit it's a place of danger
Gotcha.
and not greater danger.
Gotcha. Anything else?
Respect. No, thank you.
Thank you. Do you have anything else?
Yes, Mr. Chief Justice, if I may. I would just like to point in on your question, it's the people's position that even if movement were a required element of the OWI, as this court directed to consider Hardy, it's the people's position that even if it were, I guess, part of the elements of the crime, that it should still be scored under OV8. And also, I would just like to point back to Justice Markman's question. The legislature did intend to punish this. In fact, it made OWI with an occupant under 16 a crime against a person. It was the legislature that defined it as such, and in fact, OV8 is special in that only crimes against a person are scored for that offense. I just wanted to touch on those. If there's no further questions, then good afternoon.
Thank you. The case is submitted.